Dear students, we shall go through the provisions of the Payment of Gratuity Act 1972. The Act is part of IPCC Paper 2 Business Law, Ethics and Communication Chapter 5. I, Atul Gupta, shall deliberate upon the topic. See, gratuity as defined in Concise Law Dictionary means something given as gift out of free will. The Payment of Gratuity Act 1972 was enacted to conclude to legalize the payment of gratuity to employees of specified concerns so that there is no ambiguity whether gratuity is payable or not. The Payment of Gratuity Act 1972 defines who is liable to pay gratuity, who is eligible to receive the said payment of gratuity, what shall be the amount of such gratuity, when such gratuity shall be receivable. As we go across the provisions of the Payment of Gratuity Act 1972, an issue about accounting of gratuity shall come upon. What we shall do, refer to the Accounting Standard 15 on Employee Benefit as issued by the Institute of Chartered Accountants of India to see how a gratuity payable has to be accounted, what are the implications of that in accounting terminology. We shall try to have a brief on all those provisions of Accounting Standard 15 as we go through the legal provisions of the Payment of Gratuity Act 1972. Dear students, the Payment of Gratuity Act, as we go through, the following sections shall be dealt separately. The first part dealing with the definitions as specified under the Payment of Gratuity Act, the application of the Act, to whom the Act is applicable, the important definitions of the related terms as they are used in the Act, the eligibility of the employees to whom it is payable, how the gratuity is calculated, what shall be the basis of calculation of gratuity, the forfeiture of the amount payable as gratuity. As we go across, we shall be deliberating on all these above terminologies. The Act further specifies that there has to be compulsory insurance and registration of establishment under the Act. The whole objective within the Act is that if an entity is liable to pay gratuity, then it must ensure adequate availability of funds so that when the gratuity actually becomes payable to an employee, the fund is kept for the employee and it is not misused by the employer. To this, these provisions have been brought. Then we'll go about the nomination facilities as provided under the Act. We'll deliberate upon the time limit within which the gratuity has to be paid, how the disputes given in the Act shall be resolved, and what shall be the recovery procedures of gratuity payable by an employer. Dear students, the Preamble to the Act specifies the purpose for which the Payment of Gratuity Act has been created. It states that it is an act to provide for a scheme for the payment of gratuity to the employees engaged in factories, mines, oil fields, plantations, ports, railway companies, shops or other establishments, and for matters connected therewith. Dear students, the next important issue is the applicability of the Payment of Gratuity Act. It states that the Act extends to the whole of India, provided that in so far as it relates to plantation or ports, it shall not extend to the state of Jammu and Kashmir. It shall apply to every factory, mine, oil field, plantation, port and railway company. The Act shall apply to every shop or establishment within the meaning of any law in which 10 or more persons are employed or were employed on any day of the preceding 12 months. Such other establishments or class of establishment in which 10 or more employees are employed or were employed on any day of the preceding 12 months as the central government by way of a notification specify in this behalf. That per se means that all entities having 10 or more employees, if specified by central government, shall be covered by the provisions of the Payment of Gratuity Act. Having talked about the scope, the application of Gratuity Act, let us move to the next very important section of this deliberation that illustrates the various important definitions as provided in the Payment of Gratuity Act 1972. Dear students, the most important definition in the Act is that of an employee. It specifies that an employee is any person other than an apprentice employed on wages in any establishment, factory, mine, oil field, plantation, port, railway company or shop to do any skilled, semi-skilled or unskilled, manual, supervisory, technical or clerical work, whether the terms of such employment are expressed or implied, and whether or not such person is employed in management or administrative capacity, but does not include any such person who holds a post under the central government or a state government and is governed by any other act or by any rules providing for payment of gratuity. This, if you look at the definition of an employee, students, you will realize that it covers a wide spectrum of employee. Virtually no one is left out. You must be wondering whether articles are covered. If you read the first line, it clearly states that any person other than an apprentice, articleship that you do under a chartered accountant is covered under a separate law by the name Apprentice Act. So apprentices are not included in the definition of employee. This means that even if you would be doing your articleship very ethically, but because you are defined as an apprentice, you are not an employee, you shall not be eligible to receive gratuity. Students, the next important definition is retirement and superannuation. Retirement means termination of the services of an employee otherwise than on superannuation. Superannuation in relation to an employee means the attainment by the employee of such age as is fixed in the contract or conditions of service as the age on the attainment of which the employee shall vacate the employment. This definition is again an important definition because based on this date, the liability of the employer to pay gratuity is determined, or in other terms, the eligibility date is based on this definition. When will an employee receive the eligible amount of gratuity? The next important definition, students, is of the word wages. The Act specifies that wages include all emoluments which are earned by an employee while on duty or on leave in accordance with the terms and conditions of his employment, which are paid or are payable to him in cash and includes dearness allowance but does not include bonus, commission, house rent allowance, overtime wages and any other allowance. The next definition is that of a family. The Act specifies that family shall be deemed to consist of, in case of a male employee, himself, his wife, his children, whether married or unmarried, his dependent parents, the dependent parents of his wife, and the widow and the children of his predeceased son, if any. definition of female employee is separately specified in the Act. The Act says that in the case of a female employee, it shall include herself, her husband, her children, whether married or unmarried, her dependent parents and dependent parents of her husband, and the widow and children of her predeceased son, if any. The next important definition is that of controlling authority. The appropriate government may by notification appoint any officer to be a controlling authority who shall be responsible for the administration of this Act, and different controlling authorities may be appointed for different areas. The next definition is that of appropriate government. The Act specified appropriate government in two parts. In the first part, it states that it in relation to an establishment belonging to or under the control of the central government, having branches in more than one state, of a factory belonging to or under the control of the central government, of a major port, mine, oil field or railway company, the central government shall be the appropriate government, and in any other cases, the state government shall be considered as the appropriate government. The next important definition is that of continuous service. As defined in section 2A of the Act, the Act states that an employee shall be said to be in continuous service for a period if he has for that period been in uninterrupted service, including service which may be interrupted on account of sickness, accident, leave, absence from duty without leave, layoff, strike or lockout, or cessation of work not due to fault of employee, not being an absence in respect of which an order treating the absence as a break in service has been passed in accordance with the standing order, rules or regulations governing the employee of the establishment. The next important part of the definition of continuous service is where an employee, not being an employee employed in a seasonal establishment, is not in continuous service within the meaning of clause 1 as discussed in the previous slide, for any period of 1 year or 6 months, he shall be deemed to be in continuous service under the employer for the set period of 1 year if the employee during the period of 12 calendar months preceding the date with reference to which the calculation is to be made has actually worked under the employer for not less than 190 days in the case of an employee employed below the ground in a mine or in an establishment which has works for less than 6 days in a week and 240 days in any other case. These provisions are important because they generate the eligibility of the employee for receiving gratuity, and many questions on these provisions has been asked in exam. We'll dwell upon these questions in the next slide. This question appeared in November 2010 examination. K is an employee of RST Limited, a software company which works 5 days in a week. K was not in continuous service during the financial year 2009-10. However, she worked only for 150 days because she was on maternity leave with full pay for 50 days. Referring to the provisions of the Payment of Gratuity Act 1972, decide whether K is entitled to gratuity payable under the Act. Would your answer remain the same in case RST Limited works 6 days in a week? The next important part of the definition of continuous service deals with those employees who have been held as not in continuous service for a period of 6 months. The definition states that for the said period of 6 months, if the employee during the period of 6 calendar months preceding the date with reference to which the calculation is to be made has actually worked under an employer for not less than 95 days in case of an employee employed below the ground in a mine or in an establishment which works for less than 6 days in a week, and in any other case 120 days as may be applicable. This definition is again important as it decides the eligibility of an employee for receiving gratuity. The next part of the definition of continuous service deals with employees who are employed in seasonal establishment. The definition states that where an employee employed in a seasonal establishment is not in continuous service within the meaning of clause 1 above for any period of 1 year or 6 months, he shall be deemed to be in continuous service under the employee for such period if he has actually worked for not less than 75% of the number of days on which the establishment was in operation during such period. This definition is again important as it relates to the eligibility of an employee to receive gratuity. A seasonal establishment, for example, sugarcane factories where sugarcane is crushed to make sugar, they work for 5 months during the year. It is a good example of a seasonal establishment. This definition is again important as many questions in exam are asked from this one. Another question follows this slide. This question was asked in May 2010. It goes like this. S is employed in Golden Ice Factory, a seasonal establishment. The factory was in operation for 4 months only during the financial year 2009-10. S was not in continuous service during this period. However, he has worked only for 60 days. Referring to the provisions of the Payment of Gratuity Act 1972 decide whether S is entitled to gratuity payable under the Act. Would your answer be same in case S works for 100 days? You have two options to look for the answer, the ICAI website or at the end of this presentation. Dear students, having gone through the definitions within the Payment of Gratuity Act 1972, let us go to the next very important section of this presentation, eligibility and calculation of gratuity. Eligibility for gratuity. The Act states that gratuity shall be payable to an employee on termination of his employment after he has rendered continuous service for not less than 5 years, on his superannuation, or on his retirement or resignation, or on his death or disablement. In this case, 5 years service is not required due to accident or disease. Dear students, the next important part is the calculation of gratuity. It is based on every completed year of service or part thereof in excess of 6 months. The employer shall pay gratuity to an employee at the rate of 15 days wages based on the rate of wages last drawn by the employee concerned. Dear students, we have defined wages in the previous slides as all emoluments which are earned by an employee while on duty or on leave in accordance with the terms and the conditions of his employment, and which are paid or are payable to him in cash and includes dearness allowance but does not include any bonus, commission, house rent allowance, overtime wages and any such allowance. This raises an important question: is daily wage earner out of the scope of this whole calculation? No, this is not the case. For such daily wage earners, separate definition of wages has been created in the Act. It states that in case of a piece rated employee, the daily wages shall be computed on the average of total wages received by him for a period of 3 months immediately preceding the termination of his employment, and for this purpose the wages paid for any overtime work shall not be taken into account. In a piece rated system, there may not be the concept of basic, DNS allowance, house rent allowance, city compensatory allowance, etc. So this separate definition is there. As an extension to the previous definition, this part deals with an employee who is employed in a seasonal establishment and who is not so employed throughout the year. It states that the employer shall pay the gratuity at the rate of 7 days wages for each season. The next important definition is computation of wages in case of disablement of an employee. The Act states that in case of an employee becomes disabled due to any accident or disease and is not in a position to work on same employment, is re-employed on reduced wages at other jobs, the calculation shall be done in two parts. Part 1 is period before disablement, Part 2 is period after disablement. For the purpose of period before disablement, the wages shall be taken as wages last drawn at the time of disablement. For the period after disablement, the wages shall be considered as reduced wages at the time of termination. And for the purpose of calculation of gratuity that you shall be seeing in the coming slide, the time period before disablement and time period after disablement both shall be appropriately considered to arrive at the right figure for calculation of gratuity for such an employee. Dear students, the next important calculation is about the maximum limit on gratuity and how a gratuity calculation shall be done for an employee. The Act states that in case of a monthly rated employee, those employees who receive their salary at the end of the month, the 15 days wages shall be calculated by dividing the monthly rate of wages last drawn by him by 26 and multiplying the quotient by 15. An example is illustrated. For example, if the monthly wages of the employee is 13,000, dividing the same by 26, the result is 500. Now this 500 is multiplied by 15. The result is 7,500. This amount is the gratuity payable for each completed year of service or part in excess of 6 months thereof. This raises a question about how the gratuity shall be calculated for those employees who are receiving their salary on a daily basis or piece rated employee, and those employees who have been working in seasonal establishments. Taking from the definition we gone through in the previous slide, for those employees who are on piece rate, their average wage calculated shall be multiplied by 15 days. The resultant amount shall be the gratuity payable for each completed year of service or part in excess of 6 months thereof. The same valuation shall extend to those employees who have been working in seasonal business. The only difference shall be that for calculating the yearly gratuity payable to a seasonal employee, the 15 days shall be replaced by 7 days for each season. So the resultant value, that is the average wage multiplied by 7 days for each season, shall be the gratuity payable for each completed year of service or part in excess of 6 months thereof. The Act specifies that the maximum amount of gratuity payable to an employee shall not exceed rupees 10 lakh. Dear students, a question on how gratuity has to be calculated had been asked in May 2011 examination. The question goes like this: how is the amount of gratuity payable to employees in a seasonal as well as other establishment calculated under the provisions of the Gratuity Act 1972. What is the maximum amount of gratuity payable under the said act? The previous discussion is the answer to the question, so no further answering is done at the end of this presentation. Dear students, the next important topic is forfeiture of gratuity. The Act specifies the situations where the gratuity payable to an employee may be forfeited. The Act states that an employee whose services have been terminated for any act, willful omission or negligence causing any damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss so caused. It further states that the gratuity payable to an employee may be wholly or partially forfeited if the services of such employee have been terminated for his riotous or disorderly conduct or any other act of violence on his part during the course of his employment. Dear students, the next important provision in the Act is about compulsory insurance to be taken by employers. The Act had been amended to state that every employer should obtain an insurance for his liability towards payment of gratuity under this Act from Life Insurance Corporation of India. For reference purposes, Life Insurance Corporation of India has issued a group gratuity policy which can be taken up by the employers to settle their liability towards payment of gratuity. So, for example, if an employer decides to have the Life Insurance Corporation's group gratuity policy, then LIC has on its board actuaries who visit the entity, calculate the payable gratuity by the entity, generate the valuation based on that calculation. These actuaries are experts who are hired by LIC for the purpose of calculating gratuity payable by those entities who decide to take up the group gratuity policy of Life Insurance Corporation. Dear students, you might recall at the start of the presentation I had referred to that we might look to the related provisions as specified in Accounting Standard 15, which deals with employee benefit as issued by the Institute of Chartered Accountants of India. Under Accounting Standard 15, it is stated that an employer, for the purpose of calculating the gratuity payable, has to take services of an actuary. Actuary is an expert who has been taught the provisions how to calculate gratuity, and based on these calculations the gratuity payable is generated. Dear students, to the provision of compulsory insurance, the Act provides an exception, the exception being where an employer employ 500 or more persons may establish an approved gratuity fund. Then in this case, the employer need not take the compulsory life insurance policy. The requirement is diluted where appropriate government may exempt any employer who had already established an approved gratuity fund and who desires to continue such arrangement even if the number of employees are less than 500. So the exception is clear that where an existing fund has less than 500 and it has been permitted by the appropriate government, it can continue with the appropriate fund without having a need to take the Life Insurance Corporation's LIC group gratuity policy. And for other employers who wish to have an approved gratuity fund, they must have 500 or more employees to seek an exemption from compulsory insurance scheme. Students, the next issue is about registration of establishment. The Act states that every employer shall get his establishment registered with the controlling authority in the prescribed manner, and no employer shall be registered under the provisions of this section unless he has taken an insurance or has established an approved gratuity fund. This means that the Act is very specific on how an employer is funding the gratuity liability income. The next important provision is power to exempt as provided in section 5 of the Payment of Gratuity Act. The Act allows the appropriate government to specify exemptions for an establishment, factory, mine, oil field, plantation, port, railway company or a shop to which this Act applies from the operations of the provisions of this Act if, in the opinion of the appropriate government, the employee in such establishment, factory, mine, oil field, plantation, port, railway company or shop are in receipt of gratuity or pensionary benefits not less favorable than the benefits conferred under this Act. Dear students, keep a remembrance of this provision is exempting an establishment from operation of the Act. Students, the power to exempt continues to subsection 2 of section 5. It states that the appropriate government may, by notification and subject to such condition as may be specified in the notification, exempt any employee or class of employees employed in any establishment, factory, mine, oil field, plantation, port, railway company or shop to which this Act applies from the provisions of the Act if, in the opinion of the appropriate government, such employee or class of employees are in receipt of gratuity or pensionary benefits not less favorable than the benefits conferred under this Act. Dear students, you will note that the key difference between this exemption and the previous exemption being, in the previous exemption, the exemption was provided to the whole establishment. In this exemption, the exemption is provided to an employee or a class of employee. Further, the Act provides that any notification issued under those two above subsections may be issued retrospectively, a date not earlier than the date of the commencement of this Act, but no such notification shall be issued so as to prejudicially affect the interest of any person. The next important provision in the Act is the facility of nomination provided. The Act specifies that an employee who has completed 1 year of service shall make nomination. An employee may, in his nomination, distribute the amount of gratuity payable to more than one nominee. Employees having family shall make nomination in favor of one or more family members only. In case of an employee who does not have a family, the Act specifies that employee not having family may make nomination in favor of other persons, but such nomination becomes invalid if he acquires a family at a later date. Thus, he or she has to make a fresh nomination after acquiring the family. The Act allows an employee to change nomination at any later date. It states that an employee has a right to change nomination. For this, he shall make a fresh nomination. In the Act, appropriate government has been given power to appoint people to act as inspectors in the Act. It states that the appropriate government may by notification appoint as many inspectors as it deems fit for the purpose of this Act. It further states that the appropriate government may, by general or special order, define the area to which authority of an inspector so approved shall extend, and where 2 or more inspectors are appointed for the same area, also provide by such order to for the distribution or allocation of work to be performed by them under the Act, every inspector shall be deemed to be a public servant within the meaning of Section 21 of the Indian Penal Code 1860. Dear students, the next provision is about notice of payment of gratuity. The Act specifies that any person eligible to receive gratuity shall make an application to the employer for the payment of same within the prescribed time. The next is an important obligation on the employer, that is time limit for payment of gratuity. The Payment of Gratuity Act 1972 specifies that the employer shall arrange to pay the amount of gratuity within 30 days from the date it becomes payable. If not paid within the stipulated period as specified above, employer is liable to pay interest on such delayed payment. Interest is not payable if the delay was caused due to the fault of the employee and the employer has obtained permission in writing from the controlling authority for the delayed payment on this ground. If there is any dispute as to the amount payable or the person eligible to receive it, the employer shall deposit the amount as per his calculation with the controlling authority. The Act has a specific dispute resolution mechanism. It states that an application has to be made to the controlling authority, the amount has to be deposited if appealed against controlling authority within 60 days from the order if the aggrieved party doesn't agree with the decision given by the controlling authority. The next important provision is about the recovery of gratuity. That states that if the amount of gratuity payable under this Act is not paid by the employer within the prescribed time, the controlling authority shall, on an application made to it in this behalf by the aggrieved person, issue a certificate for that amount to the collector, who shall recover the same together with the compound interest thereon as arrears of land revenue and pay the same to the person entitled. Continuing with recovery of gratuity, the Act specifies that the controlling authority shall, before issuing a certificate under this section, give the employer a reasonable opportunity of showing cause against the issue of such certificate. The amount of interest to be added to the payable gratuity amount shall not be more than the amount of gratuity so payable. Now, dear students, we will take up few questions from past examinations. Dear students, this question had been put up in the previous presentation also. It goes like this. K is an employee of RST Limited, a software company which works 5 days in a week. K was not in continuous service during the financial year 2009-10. However, she worked only for 150 days because she was on maternity leave with full pay for 50 days. Referring to the provisions of the Payment of Gratuity Act 1972, decide whether K is entitled to gratuity payable under this Act. Would your answer remain the same in case RST Limited works 6 days in a week? The solution to the above problem is based on the definition as we have read under section 2A of the Act for continuous service. Based on this, the answer to the question is in two parts. First one dealing with situation 1, where it has been stated that K has worked for 150 plus 50 days, that is 200 days. This means K has worked for more than 190 days, which is an eligible period for continuous service. Where an establishment works for less than 6 days in a week, in this case K is eligible to be part of claim for gratuity. Second situation is that the establishment is working for 6 days in a week. Going through the definition as given in section 2A, you shall find that where an establishment works for 6 days in a week, an employee must have 240 days of continuous service. In the given example, K has worked for 200 days, so she is not eligible for gratuity. The next question from May 2010. This question has also been put in the previous presentation. It goes like this. S is employed in Golden Ice Cream Factory, a seasonal establishment. The factory was in operation for 4 months only during the financial year 2009-10. S was not in continuous service during this period. However, he has worked only for 60 days, referring to the provisions of the Payment of Gratuity Act 1972, decide whether S is entitled to gratuity payable under the Act. Would your answer be same in case S works for 100 days? The solution to the above problem, based on the statutory provisions given under section 2A regarding seasonal employment, there are two situations covered in the question. The provision in section 2A states that where an employee is part of an industry which is seasonal in nature, to be held as in continuous service, the employee must work for 75% of the days for which the seasonal establishment has worked. In situation 1, it is given that S has worked for 60 days. If we calculate 75% of the days for which factory is operating, it comes to 90 days. The total period of operation given in the question is 4 months. That means S in situation 1 is not eligible as he has worked for a period less than 90 days. Going to situation 2, based on the same logic, it is given that S has worked for 100 days, so S is eligible in situation 2 as being held as an employee in continuous service. The next illustration is from November 2012 attempt. The question goes like this. When an employee becomes disabled due to any accident or disease and is unable to do the same work and re-employed on reduced wages, how the gratuity of such an employee shall be computed under the provisions of Payment of Gratuity Act 1972. Above question is a direct question based on the discussion we have taken. The wages shall be calculated in two parts. Part 1 is wages before the disablement. Part 2 is the wages at the time of termination. For the calculation of gratuity, wages shall be taken into two parts. So also the period of employment and the value of gratuity shall be calculated. Students, the next question comes from November 2011 attempt. The question goes like this. What is the law relating to recovery of amount of gratuity under the Payment of Gratuity Act 1972 in case the said amount is not paid by the employer? The question is a direct question dealt in above discussion. On an application made to it, the controlling authority shall pass an order to collector to recover the said amount along with compound interest as arrear of land revenue from the employer who has failed to pay such gratuity. Dear students, during this part of the presentation, we have gone through the definition, the application, the eligibility, the calculation of gratuity, the forfeiture, compulsory insurance, nomination facility, the time limits for payments, disputes and recoveries within the Payment of Gratuity Act, and we have tried to solve few exam questions. Thank you for this patient listening.